everyone, and welcome to this week's episode of our live webinar series, proudly presented by immigrationquestion.com, your trusted source for real-time immigration answers, attorney access, and straightforward information you can count on. My name is Anusia Mukherjee, and I will be your host for today's webinar, Hope for Abandoned Youth, Special Immigrant Juvenile Status, SIJS, and the Road to a Green Card. For many young people who've been abandoned, neglected, or mistreated by one or both parents, the journey to safety into the U.S. can be incredibly lonely. But there's a powerful legal option that exists just for them, one that provides protection, stability, and eventually a pathway to permanent residency. It's called Special Immigrant Juvenile Status, or SIJS. And for the youth who qualify, it can change everything. But the SIJS process isn't always easy to understand. There are family courts, immigration deadlines, and legal steps that can feel overwhelming without the right help. That's why today's session is so important. We're here to break it all down in simple terms for anyone supporting a young immigrant through this process. Joining us today is someone who truly understands the issue, attorney Trisha Chatterjee. An immigration attorney based in Dayton, Ohio, Attorney Chatterjee focuses on humanitarian immigration, including SIJS, asylum, VAWA, and U visas. She's known for her empathy, clarity, and communication to helping vulnerable populations. And she speaks fluent Spanish, so she works closely with a diverse range of clients and families every day. You're welcome, Attorney Chatterjee. We're glad to have you here on the show.
Hi, Anasia. Thank you so much for having me.
Thank you. Before we get started, just a quick reminder, Immigration Question is a platform that connects users to licensed immigration attorneys. We are not a law firm, nor are we affiliated with AILA or USCIS. All legal services are provided independently and by registered attorneys on our network. So now let's just dive right in. So Attorney Chatterjee, to kick things off, what is Special Immigrant Juvenile Status and who qualifies for it?
Sure. So Special Immigrant Juvenile Status is a pathway to legal residency or to being a green card holder. The law on it is pretty clear. It says that juveniles, so generally under 18, but there is a little bit of leeway there, juveniles who have been abandoned, abused, or neglected by one or both of their parents, they can adjust their status based on their abandonment status. So whether they've been abandoned, abused, or neglected. And most importantly in that is that one or both language. So oftentimes we get immigrants who are coming in and it's mom and a son, or mom and daughter, dad and one of their children. All of those children still are applicable for SIJS or Special Immigrant Juvenile Status, because the law left that leeway. It leaves the space for one or both. At the time of filing for SIJS, you do have to be 21 years old or less. So you have to have done all of the steps to get yourself there. And you have to do it before you're 21. You have to apply for SIJS before you're 21. The time at which you can get it is different from state to state, just based on the local family courts and family court laws, because the first step for SIJS actually happens at the local level. It happens in your local family or juvenile court.
All right, perfect. Thank you for that overview. Now let's dig a little bit deeper. What are the key eligibility requirements a young person must meet to apply for an SIJS, especially in cases involving abuse, abandonment, or neglect?
Yeah, so you have to be a juvenile. So that is defined differently between states. So I guess kind of relatedly, I guess the first step to applying for SIJS happens at the family or local court level. Somebody has to petition for custody of that juvenile. And that's where the state and local laws come in, because some states will allow you to petition for custody up to 21 years old. So states like New York, you can petition for SIJS at up to 21 years old because you can give custody up to 21 years old. Whereas here in Ohio, you have to be 18 or younger. If you're 18 years old, you're no longer eligible for SIJS in Ohio. So you go to the family court and whoever is petitioning for you, I have seen older brothers, older sisters, aunt, uncle, a family friend, any of those people can petition for custody of the child, of the juvenile. Once you have petitioned for that custody, and the judge has to put very specific language in the custody order, once that is granted, all of those children who are under that custody order with the applicable language, those are the people who can apply then for SIJS. So for SIJS, there's two levels. There's the local level, and then there's the federal level.
Mhm, mhm. Okay, that makes sense. My next question would be, now, once a young person qualifies, what does the actual process look like? Can you walk us through how an SIJS case begins? Does it start at family court, immigration court, or both?
So I think that's kind of what I was talking about, is it starts very locally. There's just the custody order. So that's going to your local juvenile court or family court judge, depending on your jurisdiction. And in that court, they grant custody of that child. In those findings, they have to use that abuse, neglect, or abandonment language. So generally at the hearing that you have in local court, especially in courts that are really familiar with SIJS, which I'm really lucky that our courts are very amenable to SIJS. We're all fighting for it as often as we are. So our judges are very good about making sure that they're eliciting the testimony that they need. So for example, if somebody is coming from their home country, I'm going to ask and elicit the testimony from the custodian and the child, if applicable. What was happening in your home country? Was it safe for you in your home country? Were you supported in your home country by a parent, a guardian, whoever it may be? If not, what happened? What was going on? Why did you feel the need to escape? And why were you, or what happened that made you feel like you were being abandoned or neglected or abused? And those stories are obviously different. And some of the time in those hearings, I'm not trying to get testimony that dad or mom is a bad guy. And that's an important distinction that we deal with a lot, is mom or dad, they're not a bad guy. Their health isn't good. So they weren't able to take care of me. We don't have money. So I have to work even though I'm 10 years old. I have to help on the family farm. I didn't get to go to school because it was too far away and we didn't have the resources to go to school, get school supplies, be adequately dressed for school, have adequate anything for that. My family couldn't support me. And that, in the eyes of the family court, is sufficient for a finding of abandonment or neglect. It's not that your mom or dad is a bad person. It's that they can't support you, and you are better off in the hands of somebody here who can support you and can ensure that you have access to resources that maybe you don't have in your home country. And some of the other key questions we ask to elicit those answers from the clients, the parents, whoever it is, did you have enough food to eat? And I deal with a mainly Hispanic audience, so that answer is oftentimes, yes, we eat rice and beans once a day. And then the follow-up question to that is, are you eating more here? And maybe they have better access to food here where they say, yeah, now I eat, I get chicken maybe once a day, or I get more sustenance once a day. And that's enough as well to say, you were neglected there. Yes, you were eating, but you were eating once a day. And now you're being fed more sustenance. You have more access. A lot of courts really focus on schooling. That's really important to a lot of the judges. They want to make sure that the kids are going to school. So they'll ask about that. Are you in school here? How are you doing in school? Making sure that they are being given those resources. So those are the types of questions that the judges at the local court level tend to ask. They'll also ask, where's your closest hospital? Where's your closest police station? If something happens to you and you go to the police station, will they help you? Because, in a lot of countries, policing looks different than it does here. So they're not taking reports. They're not going to protect you the way that you're protected here. So those are distinctions that we make at the family court level for the findings that we need. So once we have the custody order that grants custody to mom, dad, sister, brother, friend, whoever it may be, that's when we can apply for SIJS. The first step is at USCIS. We apply for an I-360. It's a petition for Special Immigrant Status. You fill out that form. There's a specific portion of it for Special Immigrant Juvenile Status. Usually with that application, we have to send the custody order. And what I like to do is highlight the portions of that order that show the abandonment, abuse, or neglect language, sometimes all three. Once that 360 is approved, which it's a long process to get that approved, it doesn't happen very quickly, then you get what we call deferred action. So deferred action means you are in line for a visa, which is going to become your green card. If once you're granted deferred action, it's a type of legal status almost, where you are waiting out a green card. They know you're here. They know that you are going to be able to adjust your status once a visa comes available. Therefore, they're deferring any further action that they may or may not take.
All right.
Once you have that approved visa, that's when you can apply for your green card. So we like to say it's a 3-step process. It's a little different. There's more steps if you're in immigration proceedings at the time.
All right. That makes more sense. All right, perfect. Next question would be, once someone is approved for SIJS, how do they move from the approved to a green card? Are there extra steps or waiting periods that families or sponsors should be prepared for? I know you kind of answered that, but could you elaborate a little bit more?
Yeah. So there's the time where there's kind of 3 big waiting points. Some are shorter than others. So the quickest one is usually at the family court level. We elicit testimony or whatever your court's process is, your local court for custody, and you wait for the custody order from the judge. Some judges will turn that around really quick, especially if the attorney or whoever you're working with gives them a proposed order that they can kind of just mend into what they heard in court, giving them the specific language that you need. A lot of judges really appreciate that because it helps them help you. So that's the first wait. That kind of just depends on your local court. They're usually pretty quick with things like custody, just because they're looking out for the best interests of the child. Then you do your I-360. You fill out that form, and again, you wait for the approval of your I-360. That, again, it's a span of time. It could be anywhere from, in a few weeks you get your approval, or in a few months, maybe even a year, 2 years, you get your approval for your I-360. That's when you get the longest wait, is once your I-360 petition has been approved, because at that point you're in the visa line, and the visa line, especially for a green card, is exceedingly long. They put out a visa bulletin every month. So I think right now for some countries, we're still dealing with applications from 2019, 2020, and 2021. So it's not that process is the longest. It's just sitting. But during that process, while you're sitting with your approved I-360, you can apply for work authorization and your social security number. So in that meantime, you are able to work and support yourself under your work authorization card that you get from having an approved I-360.
All right, perfect. I think this comes to my last question. So that brings us to challenges. What are some common roadblocks applicants face in the SIJS process, and how can legal advocates help youths and their caregivers navigate through these issues?
Yeah, I mean, there's certainly roadblocks. For example, I know in one of my local courts, one of the judges has recently been giving us a hard time in even getting a custody agreement when the petitioner is a parent. Apparently in our local ordinance, it says that if a child only has one parent here, custody to that parent is automatic. So we don't need to have a custody order because the parent already has it. So that was a roadblock that we faced. We ended up just working really hard with the judge so that even if the judge is saying this case is moot because mom is here with the child and mom has custody, now the judge says, father isn't here for these reasons. And therefore, the child is still getting the language that they need, the findings that they need from the local court judge, though the judge is still saying that it's moot almost. They're not going to give us an order of custody, but they are going to give us the findings that they need. The judge's order has to have that specific language, though. It has to say that the child was either abused, abandoned, or neglected. So ensuring that you're getting that language is really important. I've also found at our local court level, the manner that testimony is being taken is very different. At my local court, I ask my client, the petitioner, the parent, or the guardian, I ask them questions and they answer it. I've gotten very familiar with the judge and what I know he wants. So I'm able to go in there and produce that testimony efficiently. Whereas I'm in Dayton, but in Cincinnati, one of the judges, she's done so many of these that she asks the questions from the client. But that can be really scary for the client because they're looking for a safe place and they want to make sure that they're giving the judge everything they want. It's intimidating. I have also found that another roadblock at the family court level is a language barrier. I'm lucky that I speak fluent Spanish. So when I am giving a question in English and the interpreter is interpreting that question to the client and then interpreting their answer, there are often times where I have had to stop and ask the questions multiple times because I know that it's not being interpreted the way that the client is saying it. So for example, I remember at one point I said, "How are you related to the child?" And in Spanish, the word tío means uncle and primo means cousin. So the child said, "This is my primo." And the interpreter kept saying, "It's his uncle." And I asked it 3 more times. And eventually I had to just stop and look at the interpreter and say, "Well, sir, that's not a perfect translation. And it's so important for the record that all of the findings are going to match what the client is saying." So that is one where you just have to be hyper vigilant of what's happening in the courtroom to make sure that we're keeping a clean record. They also will sometimes get caught up because it's a local court. And when you are petitioning for custody, it's not quite a lawsuit, but it is a petition. So if, say, my older brother was petitioning for me, we would have to put my parents in our home country on notice that is happening. And that's often really difficult for a number of reasons. The first is I might not have contact with them. So I don't know how I'm going to send over a piece of paper for my mom and dad to sign that says, "I sign away my rights to my child," or "I sign away and I know that this is happening in custody court and I'm okay with it. I understand it. I will not be there." Or you pay a fee for it to be noticed by publication, or service by publication, which is they put in your local newspaper, "Court hearing happening for XYZ youth on this day at this time. This is notice for this person." So whoever, mom, dad, cousin, brother, whoever it is that they're petitioning for custody from, they have to do service on them. So even if it's by publication, for publication to happen, it takes longer. So that's another roadblock. I think one of the biggest roadblocks is people don't realize that this is available to them. And then by the time they're coming to our office or wherever they're going, I'm 17 years old. I turn 18 in 9 days. What can you do? And it's such a rush from us to try and get it on the local court's docket in time. We're really lucky because in our local courts, they will just make it happen as best as they can. I've had them say, "If you can get everything filed in the next 2 days, we have an opening in 2 days." And then it's just a rush of making sure all of that I just described gets done. So that's a major roadblock, is just making sure that people are aware that this is available to them and that we need to do it by a certain time. So those are a lot of the big ones. And then there's also obviously the roadblock of fear, because oftentimes the petitioner, the person who's going to be getting custody, is also undocumented. So they have a fear of going into the court and presenting all of this information. But that's usually one that we can get over pretty quickly.
All right, perfect. To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you here. We are immigrationquestion.com, a 2-in-1 platform built with lead and case management features to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who have used our platform. You can ask your immigration questions for free in any language and get connected with a licensed attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. And some exciting news, we've just launched our new app built to serve both attorneys and users seamlessly. Attorney Chatterjee, as a licensed legal professional working closely with both documented and undocumented immigrants, how do you view the role of platforms like immigrationquestion.com in supporting and empowering the immigrant community today? In what ways do you think it adds value to individuals seeking legal guidance and trustworthy information?
Yeah, I think right now there's a lot of fear in the documented, undocumented, in between communities. There's a lot of fear because you're seeing things in the news cycle. You're surrounded by a community that's also scared. So, for there to be a place where you can go and ask your questions and almost feel a community of support or have direction of what you should do next, I think is incredibly important. The immigration system is exceedingly confusing and intimidating. It's built to be that way. So when clients come in and they talk to me even now and they're saying, I'm really scared because I don't know what happens next, but I know I'm too scared to go home. I know I want to stay here and support my family. I just don't know what that looks like. So I think if there's somewhere where you can go where you can safely ask those questions, ask the questions that you're too scared to ask, or take to a lawyer's office. Lawyer's offices oftentimes charge for consultations, charge for your questions, and it's hard to find one. People who are immigrating from countries where they're speaking languages that aren't English, sometimes it's really hard to find a lawyer's office who speaks your native language and can help you in your own language. I mean, there have been multiple times that at the firms that I've worked at, we don't have somebody who interprets in French, for example. And luckily, my big brother speaks French. So I'm able to call my brother and he'll interpret between me and a client, but not every language is that easy. It's not really ever that easy to find somebody who speaks like a niche language. There's always the issue of a language barrier. So having somewhere where you can go and ask your questions and find somebody who can either A, use Google Translate on it pretty quick, or B, can just understand it and help you is really critical, especially with how much things are changing and how intimidating it is now.
Definitely. Thank you so much for that. We love to hear it. Before we dive into the live Q&A session, one last question that I have is for undocumented youth who are already in the removal proceedings, how does having or applying for an SIJS impact their deportation risk or their ability to stay in the US legally?
It's makes a world of difference. So it kind of goes back to that piecewise process. When we get somebody in who is already in proceedings, but we know they're eligible for SIJS, the first thing we'll do is ensure that we're moving on that SIJS. Then once we're in court, we're able to file for that child in immigration court. We will file either a motion for status docket. Status docket means you're not on the court's calendar. Rather, your attorney is updating the court with where we are in the process. That means writing a quick motion to the court that says, we just got the I-360 approved, everything's looking good, everything's on track. So we either try and get you on the status docket, which is just updating the court. You're no longer really in proceedings. You're not in deportation court. And then the other thing that we'll do once we are on status docket, or sometimes we can skip status docket altogether, is a motion to terminate. The immigration judge has the vested ability to terminate your proceedings because you are eligible for relief in another court or in another service. So I-360s go through USCIS versus in the immigration court where you are in deportation proceedings. So once we have something in paper, which is either a receipt notice, your approval notice of your 360, at that point, we're able to terminate your proceedings in court. In Ohio, at least in the Cleveland court, there is one immigration judge who handles all of the juvenile cases. So Judge Owens has just the docket of juveniles. So most of what we do with him is I will be filing a motion to terminate. Almost never do we go to a full hearing with the juveniles.
All right. Thank you for that, Attorney Chatterjee. That was really insightful. Now we'll move on to our live Q&A session. This is your chance to ask Attorney Chatterjee your own questions directly. Just type them in the chat or call us live at 516-703-3483. All right, let's see. Our first question is, I'm already 20 and I live with my aunt. Can I still apply for an SIJS or is it too late?
That will depend on the state you're in. In Ohio, it would be too late as you have lost the window. You're over 18. But then there are several states where you can still petition by 21. So before you're 21, but you would have to move on it pretty quick. I know states such as the one that we always say is New York. I know there's other states where you can still be petitioned by your aunt. I also would recommend, given that you're 20, I don't know how you entered the country, but I would also recommend a UAC asylum, which is unaccompanied child. Those asylums are exclusively in the jurisdiction of USCIS. They're not with the immigration court. So that's another way that you could get your case terminated. It just depends on where you are in the process, how you entered. But 20 in Ohio, that would be too late for SIJS. It just depends on where you are.
Perfect. And then our next question is, my father was violent, but my mother is still with me. Can I still qualify for an SIJS even if I live with one parent?
Yes, that is the great thing about the way the SIJS law was written is it just has to be abandoned, abused, or neglected by one or both of your parents. So as long as one of them has abandoned, abused, or neglected you, you are still eligible for SIJS. It just depends on the state court that you're in. You have to make sure that they are willing to do a custody finding of some sort.
All right, perfect. Our next question is, can I apply for SIJS even though I'm already in removal proceedings?
Absolutely. It is separate from your removal proceedings. So once you've applied for your SIJS, you can terminate your removal proceedings because USCIS will then have jurisdiction over your SIJS and your green card. So once you're in line for residency, the court will usually just terminate your immigration proceedings, your deportation proceedings, because you have a pathway to residency or a pathway to a visa. So if you have a way to get relief in another jurisdiction, in this case USCIS, the court will be more than willing to terminate your case once you've applied for your SIJS.
All right, perfect. Next question is, do I need to file everything before I turn 21, or is it okay if I just get the approval before that age?
As long as you have the approval, your custody order by the time your state court requires it. So as long as you get it before you're either 18 or up to 21 in some states, as long as you have that, you are still eligible to apply for SIJS up through turning 21.
All right, perfect. Next question is, my cousin raised me since I was little. Can she still be my legal guardian for SIJS?
Absolutely, as long as she's over 18.
Perfect. Next question is, if I get a green card through SIJS, can I still bring my mother to the US later?
This is a really interesting question. I don't know the answer. We have been discussing this even at our office because we haven't had anybody who has been granted SIJS and then has also gotten their green card and gotten to this process. I do wonder. We all are kind of sitting on this one because, you know, your custody order is going to say you were abandoned, abused, or neglected by your parent. And then for you to then petition them over, I don't know what the government is going to be doing about that. Your green card category is based on how you adjusted status. So USCIS knows how you got your green card, and then when the time comes, how you naturalized. I think my inkling, this is just what I think is, if once you've naturalized and you're a US citizen, the paper trail is less. So it may be worth trying to petition your mother, but I can't say either way whether or not that would get approved just because of the nature of special immigrant juvenile status. You know, if your paperwork only says that dad abandoned you, I think that would be different. And then, or if mom petitioned for your custody here in the States, I think that would make a difference. But we've all been kind of making guesses about what that looks like, actually.
All right, that's okay. That makes sense, though. Next question we have is, where can I find a lawyer who understands SIJS? Everyone I ask keeps saying they don't know what that is.
Oh, that's tough. I know that there's a lot of people who specialize in SIJS, especially like I know that there's firms here who it's all they do, or they have a very specialized attorney who just does it. I'm sorry that everyone says they don't know what it is. You just gotta keep looking, unfortunately. It has to be a local attorney. They have to be able to deal with your state court issue, because the the thing with immigration is that a lot of it is federal. So even though I'm barred in Ohio, with most immigration cases, I'm able to take it even if it's in a different state. But for the SIJS piece, you do have to be barred in the state where you're going to be going to the local court.
All right, perfect. Next question is, if we have a next question, let's see. Oh, okay. I'm in New York. I didn't realize the age cutoff for juvenile status was different from state to state. So it's more like a statement, I guess.
Yeah, we can't legally ever tell anyone like move to this state. You'll definitely be able to do it. But when I do have a client in my office who says, "Oh, my aunt lives in New York. I just moved here for work or whatever, but like I live with my aunt," I'll always say, "Well, then she should petition for you because she does live in New York and you do live there with her full time and you're just here for work."
All right, perfect. Any other questions that we may have? I'm assuming no. All right, that was a great way to end the show. Thank you so much for joining us, and a special thank you to our special guest, Attorney Chatterjee, for your practical and strategic insights. We hope this webinar helped answer your questions on the Special Immigrant Juvenile Status. Remember, at immigrationquestion.com, you can ask your immigration questions for free and get connected with the licensed attorney in good standing who can help you better understand your options. You may also qualify for a free confidential initial consultation. Just visit our website to learn more. Don't forget, you can rewatch this session or listen to the previous episodes on Spotify. Just search for Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening edition regarding another burning immigration topic. Trust us, you don't want to miss it. Once again, thank you, Attorney Chatterjee, and we look forward to having you back soon. Thank you.
Thank you.